Ready, start. It was submitted that the right to a speedy trial is an essential facet of Article 21 of the Constitution. The segregation of the appellant's trial subserves this constitutional guarantee by enabling timely progress of the case. On these premises, the learned counsel prayed for dismissal of the appeals and for upholding of the impugned orders directing segregation of the appellant's trial from that of the co-accused, submitting that the same are legally sound, procedurally proper, and constitutionally justified. We have considered the submissions advanced by the learned senior counsel for the appellant and learned counsel for the respondent and have carefully perused the materials available on record. The principal issue that arises for determination in these appeals is whether the orders of the trial court, as affirmed by the High Court, directing segregation of the appellant's trial from that of the co-accused and requiring the filing of a separate charge sheet solely on the ground that the appellant is a sitting MLA are legally sustainable. Apparently, FIR numbers 149 and 150 of 2023 were registered in the aftermath of large-scale communal violence in the Nuh district of Haryana, which resulted in serious law and order disturbances, loss of lives, and extensive damage to both public and private property. These FIRs named several individuals, including the present appellant, and alleged the commission of offences such as rioting, dacoity, mischief by fire, and criminal intimidation. The prosecution case proceeds on the basis of an overarching conspiracy said to involve all the accused persons. The charge sheet reflects a consolidated investigative approach founded upon common evidence. It is undisputed that the prosecution relies upon largely common witnesses and interlinked evidence against all the accused. Despite the unified nature of the allegations, the trial court ordered segregation of the appellant's trial on the premise that proceedings were being delayed due to the repeated non-appearance of certain co-accused. The court also noted that since the appellant is a sitting MLA, his trial needed to be taken up on a day-to-day basis in view of the directions issued by this court in Ashwani Kumar Upadhyay versus Union of India within bracket supra bracket close concerning expeditious disposal of cases against legislators. Consequently, by orders dated 28/8/2024 and 2/9/2024, the trial court directed the police to file a separate charge sheet against the appellant. Aggrieved thereby, the appellant preferred criminal miscellaneous petitions seeking quashing of the proceedings, which came to be dismissed by the High Court. In the present appeals, the challenge has been confined to the segregation of the appellant's trial. The appellant submits that the offences alleged against him arise out of the same transaction as those involving the co-accused, and hence, by virtue of section 223 CRPC, a joint trial ought to have been conducted. It is not the prosecution's case that the acts attributed to the appellant are distinct or severable. According to the appellant, conducting a separate trial would result in a serious prejudice to him and impair his right to a fair trial.